All right, I sent that over.
Okay, just waiting on it to come through. Okay, I have it posted. Let me just go verify that it is working. Okay, you're good to go.
Okay, let's call the meeting to order and identify the participants. Warren Lowe,
Carla Burnett,
Kenneth Rochelle.
Rob Dames.
Van Colada.
you got everybody?
Yeah, we got our staff, Miss Wilton, Miss Sutter, Mr. Cook, Miss Jacinta,
Okay,
Tracy, and Melissa.
okay. And the agenda meets the criteria. Um, I doubt if we have any public comments yet.
No,
Van?
but you have no public comment at this time.
Okay, so we want to add an item to the agenda. And this has to do with a listing by some health personnel at the Willis-Knighton system in Shreveport.
Just need a unanimous vote to add it, please.
Can I get a motion to add that?
Motion to add the issue to the agenda.
Second.
Okay, all in favor?
Aye.
Okay. Do you want to tell us about that, Lauren?
Yeah, sure. So the issue was brought to your attention, I think, by a PA that works in the space or an MP that works in the space, that on the Willis-Knighton website, they were showing a medical psychology specialty, and that under that specialty, they had an NP, a PA, and a psychiatrist that were practicing psychology. Yeah, that were practicing medical psychology, but they weren't licensed. When you brought this up in June, I called around and left a couple voicemails, and I don't think I ever got to the right person. And then it kind of just got put on the back burner. So I'm glad you brought it up again, because I was finally yesterday able to reach the VP of Legal Affairs for Willis-Knighton, which is Kelly Elrod, and she was super helpful. And so when we brought it to her attention, she kind of immediately went to work on it. And so if you go to their website now, not only is the medical psychology specialty removed as a specialty that you can search for, but those three providers no longer have it on their provider page. And she did check with the Center for Mental Wellness, which is the division of Willis-Knighton that they work in. And it did seem to be just a coding error or an IT error on the website, and they weren't actually practicing it or in their actual practice. So it was, innocuous, but it has now been resolved. And she was well aware of the issue of holding ones out to be that, to be a medical psychologist without being licensed. And so, yeah, it's resolved.
Thank you, Lauren. Appreciate it.
Of course.
I didn't want to file a formal complaint because I felt like it was just a misunderstanding and not any intention to deceive or anything like that. So I'm glad you were able to take care of it. Thank you.
Yeah, it did seem to just be a misunderstanding. And the providers themselves weren't under the impression that they were actually practicing medical psychology. It was just an issue with the website.
Right. Okay, good. Thanks. Okay, so the next item on the agenda is the rule changes that we worked on last time. And I think most of those have been incorporated into this latest revision of the rule. And thanks to Lauren and Patricia and Van and whoever worked on it, because really got, I think, everything we discussed last time into the rule. And I thought I'd looked at the rule very, very carefully. initially, and I didn't catch LSBPE several times that y'all caught. So I know you looked at it very carefully. We can go through it. I think everybody should have a copy of it. If there are any questions or concerns, there is an issue we have to address toward the end of the rule about whether we refer to the primary care provider exclusively or whether we refer to the physician, and we'll try to come to that. But is there anything that anybody sees or has any concerns about? I have one thing on page 3. Well, it's of course this is my printout of the rule that the revision that was sent out, but it's paragraph 3905. I'm sorry, 3907. Number 6 and number 7 seem to be saying pretty much the same thing. It seems to be a little redundant to me.
I had the same thing marked on mine. I agree.
Should we drop the 6 and keep the 7, or keep the 7 and drop the 6? Which is the same thing.
I think it's pretty much the same thing.
All right, well then let's go ahead and drop the 7.
Well,
leave-
for
I would-
6, it's saying that you have to have passed the boards within 3 years, like within the last 3 years. And 7 is saying you have to pass the boards and completed at least 3 years of clinical experience as a licensed psychologist. So,
I would keep 7 then.
Correct. I
yeah.
agree.
So do you want to also put in 7 a 3-year time difference? Like, I mean, a within 3 years thing they have to pass the boards, or just drop that? And so it would open it up to someone who had passed the boards, 10 years ago.
I think that's part of the law, though, isn't it, that they have to do it within 3 years?
Well, if that's part of the law, you should probably keep both of them, but maybe we should make 6 more clear that that's what it's saying.
We could also drop the has passed the national examination pharmacology and just put 7 as successfully completed at least 3 years of clinical experience. Why don't I share my screen? That way I can make the edits in real time.
I'm dropping
Okay.
you off. You want to go ahead and share?
Okay, 1 second.
I do like that 7 specifies as a licensed psychologist.
Yeah, that's something that we talked about last time that y'all were debating what to require. So what we could do is, since 6 says within 3 years you have to have passed the boards, and then we can kind of get rid of this thing. But can you work as a licensed psychologist without being board certified?
Yes.
Psychologists aren't
I mean,
board
yeah, if you're
certified.
licensed, yeah.
Okay. Perfect. Because since they're both 3-year times, I didn't want it to be,
Yeah, that was a little confusing, but no, I think that works out well.
so we can just get rid of that. So 6 would say within the last 3 years taken and passed a board, a national examination psychopharmacology. And then 7 would say successfully completed at least 3 years of clinical experience as a licensed psychologist.
Yes.
Yep.
Is that how y'all want 6 to read? Do y'all want to clean that up, or does that work?
I think it works for me.
Yeah, I think it works.
Alrighty. Let me know where you want to head to next.
May I ask a question about semantics? Is have correct or should it be has? On 6.
let's see how this sentence starts. To be eligible for a license to practice as a medical psychologist, an applicant shall have
Have.
within the last 3 years.
Okay,
Yeah.
gotcha. All right,
Catch.
thank you. I didn't get any agenda or any publications to review before this meeting. I had asked for it, but never got it, so.
Did you get your notice about finding them in the cloud share, Rod?
No, I didn't get that.
Okay. Y'all download all of those, but I'm sorry, we'll try and make sure you get them on a regular basis.
Great, thank you.
So, on the next page, on my next page, under paragraph 3911, 6A, should that just be 1 hour instead of 1 hours?
1 second. This Word document is being funky.
Okay.
I think you're correct. But we'll see what the lawyer says.
Sorry, where are we looking?
Okay.
3911, section 6A.
Oh, yeah. Okay.
All right.
And this is how y'all wanted this, because I know I was working off of our notes and the video from last time when I was making the edit. So like just double check that that's how y'all want that to read, because we didn't go over and actually like approve the language in the meeting.
Yeah, I think that's exactly what we talked about.
Mhm.
Okay.
Okay. I'm glad you caught the LSBEP. I don't know how that got in there. I don't really have anything.
I had one other thing I noted in 3551, where it says, successful completion of the law and rule medical psychology examination satisfies this requirement. Should we specify that that is through the LSBME? So successful completion of the LSBME law and rules and medical psychology examination, so they know exactly what we're talking about.
Yeah, I don't have a problem with that.
Sure.
Seems reasonable.
Okay.
That was all my comments.
Well, so if we get to paragraph 6115, this is where you have the marginal note, Lauren, about are we changing all mentions of primary attending physician to primary care provider? And if we follow the law, then it is going to say primary care provider. But I definitely think we need to insert something that is in the law, if I can find it. Here it is. So in the law, it says, medical psychologists shall prescribe only consultation collaboration with the primary care provider and with the concurrence of the primary care provider. And then this is the language. However, when a medical psychologist consults and collaborates with a primary care provider other than a physician, the medical psychologist shall include the supervising or collaborating physician consultation, collaboration notices or summaries that may be required by this part. So basically what that says to me is that, yeah, you may be treating with a nurse practitioner or a PA, but you're always collaborating with the supervising or collaborating physician. And I think that needs to be in there. Maybe more than once.
You want to just reiterate that last statement in the rules?
I think it needs to be in there, man.
Lauren, what do you think?
I agree. I think that what we're trying to do here is sort of standardize the relationships between the medical psychologist, the collaborative physician, the attending physician, those kind of people. And I think obviously spelling it out makes it more clear to everyone involved.
So we're saying if it's a nurse practitioner
Or a PA.
or a PA, the medical psychologist needs to collaborate with that nurse practitioner's or PA's supervising physician.
Okay,
It's
just to get the language straight, it would be the collaborating physician with the nurse practitioner, supervising physician with the PA, correct?
Well, now wait,
Exactly.
nurse practitioners have collaborative arrangements now.
This says collaborative. This says collaborative or consulting.
Right. So it should,
Or supervising. It
because,
says supervising or collaborating.
yeah, because the nurse practitioners, with the scope of practice kind of stuff, they're no longer supervised, they get collaborative agreements.
So this says if you're collaborating with a PA or an NP, the medical psychologist shall include the supervising or collaborating physician. I think it should say in consultations, collaborations, notices, updates, or summaries that may be required by this part.
Yeah, the clearer the better.
And maybe I was mistaken. I was under the impression that what we were saying, the intent was that if it is a nurse practitioner or a PA, we collaborate with them, but we make sure that we include a note that goes to the supervising physician. So are we saying now that there needs to be a direct communication with that supervising physician above and beyond just sending a note?
Well, I think there's a number of ways to collaborate, and I think sending the note is good. I think the key here is that you all in your area need to understand that while the nurse practitioners think that they practice medicine, they don't. And while the PAs think they're trying to get to practice medicine, they aren't. And the real person, they are the physician's extender. And you really are working with the physician through them. So they think you're working with them, but it really is not the way the law reads.
Mhm.
And I think so the way we clear it up is, I think, by what you're saying. You can collaborate by just making sure that the physician knows what's going on, because if the physician gets a note and says change, that's, and I can tell you, we've had PAs who'll say, you don't send the reports of surgery to my supervisor, you send them to me, I treat the patient. No, that's not right. It's the supervising physician that treats those patients.
Sure. Yeah, I think if we clarify that we can satisfy that by sending a note. I think that, because I think that's where the confusion is going to come in.
Well, I think what's in the law covers it, really. This is language right out of the law.
Well, if you want to get granular, and that gets kind of granularly saying note, say the most expeditious and appropriate way to communicate, because you may not want to take time to send a note. You may want to pick up the phone and say, this is something we need to intervene immediately, doc. What can we do? But when you say note, it does get kind of granular. Just say the most appropriate and expeditious way of communicating with the physician.
Warren, were you suggesting we put that phrase that you just took from the law in 6115 and this letter A?
Yes.
Okay. I mean, if it's what's in the law, I have no problem with us cutting and pasting it right there if that's the appropriate place for us, because that's what the law says.
I mean, it really kind of lays out the kinds of conversations you can have with the supervising or collaborating physician can include consultations, notices, updates, summaries.
That's spelled out in the law because I don't remember.
Yes.
Yeah, then I would think that that's sufficient.
All right. Lauren, are you able to find that in the law?
Yeah, I just pulled it up. So let's see how this works.
Warren, I'm writing those items for the new quiz in my head as we speak.
Facebook and Instagram probably don't work.
Technically, it wouldn't work because it's not HIPAA compliant.
Right.
As simple as that. Do y'all want to tweak
No,
this a little bit and
I think
expand on it?
I think that looks great.
Agree. That's granular enough.
So what if we, at the end of that, if we just put maybe required by this part?
Because that normally refers to the part of the law.
Oh, okay, gotcha.
We could do it like by this chapter or by the rules, but I think that's kind of implied.
Yeah.
Okay, gotcha. Okay. So then, in every item below that, it would
Physician.
read primary care provider.
Mhm.
So every instance of physician, so every with the patient's primary care provider,
Mhm.
established
Right.
with the primary care provider or directed by the primary care provider.
Right.
Okay. I'll make those changes
Okay.
if y'all want to move on to something else.
Okay. I think,
And that change here too, that in the event that they don't have a primary or attending physician, so of a primary care provider, like that doesn't,
yeah,
that's good
Yeah.
too. Okay.
yep.
Just wanted to make sure, certain.
I didn't have anything else. Anybody else have anything?
Just Lauren, on 6111, 6117A, where you just said primary care provider licensed by the board. So that would, I just want to make sure how we address someone who says, I'm an APRN, I'm a primary care provider, why can't I participate in this? And it's really addressed in the law, and we don't have to worry about addressing it here. Is that correct?
I just took it out. I think that was a leftover.
Okay.
Unless
Yeah.
y'all think we should need it, but I think you're right that an APRN isn't going to be licensed by us.
Right. Yeah, I think so.
Yeah, so good catch. I just deleted it.
Okay, so, I mean, are we ready to submit it to the register? Right? Oh, it has to go to the board first, of course.
Board's got to say, okay.
Yeah,
Yeah,
so it's going to go to the board and then we'll put together a financial impact statement, an FEIS, I forget what the economic and impact statement. And then that goes to the legislature, they approve it or make changes, and then it'll go to the registrar.
when it goes to the register, Lauren, I hadn't looked at a rule revision in so long. When it goes to the register, does it indicate the parts of the rule that are being revised?
Yeah, so I'll take this document and turn it into what's called a notice of intent. So it'll only have the rules that we're actually changing to the registrar. So like we're not going to reprint all the
whole
extra parts
thing.
that we haven't changed.
Okay,
And then it will show the new version. It won't show the strike throughs or anything like that, but it'll show the new version. And that will be published in the Register, giving notice to the public, like, hey, we're making these rules. And in that notice, it has like the information for public comment and if they want to send and have a hearing, things like that. And then there's a public comment period for like 45 days or so.
Okay, that's what I was gonna ask you. Was it 45 or 60 days or something? Okay, good. So we got a little while before it's gonna appear in the register then. It's got to go through these other processes.
Yeah. So I would say closer to the end of the year,
Okay, that's
just
great.
depending.
Yeah, that's great. Okay, anybody have anything else on this? Okay. Next item on the agenda is just a clarification with Van. I know a telehealth rule or telehealth rules are being developed. Are the telehealth rules developed for each discipline under the board, or is there one telehealth rule with cutouts for prescribers, whatever?
It is my utmost desire to have one rule. What happened, we always had telemedicine and then we had telehealth. A year ago, year and a half, 2 years ago, I should say, Senator Mills changed everything to read telehealth. So what we're trying to do is get everybody's input and put together a generic telehealth rule that applies across the board.
Okay.
And so again, we'll be coming back to you with some language in the not too distant future that says, this is how it's going to read. Is this going to be a problem for y'all? But it's basically going to be, you got to use HIPAA compliant methodologies. Patients got to know, you got to be licensed. Whoever's providing that service has to be licensed in the location where the patient, we're going to recommend domiciled. But again, and the reason I say that is if you're treating a young person who is living and domiciled in New Orleans, but decides to go away to college in Alabama, do you have to stop treating them? Well, they're not domiciled in Alabama, they're domiciled in New Orleans. And so that's what we're trying to protect you all for.
Yeah, I like
That's
that.
the kind of stuff we're trying to, and you need to understand this whole telehealth explosion of services has really changed a lot of things, and the federal government is looking at the definitions as well. What the FSMB is considered stuff like where they're registered to vote. I mean, just crazy things like that. I think domicile is a standard enough term, but we're trying to get all those things together to recognize what's going on, because as we get more and more compacts, there are going to be people coming in to do stuff in Louisiana, and then there's going to be people in Louisiana who want to do stuff outside of Louisiana. And we got to make sure everybody understands those key issues.
There's something called SIPAC that is, I'm not an expert on it, but it was developed by the Association of State and Provincial Psychology Boards, and they've kind of separated themselves from it. But if a state passes legislation, and I've asked for a template of the legislation, and nobody's been able to give it to me yet. But if you meet the requirements to be a member of SIPAC, this allows you to treat patients in any state that has affiliated with SIPAC. And this is probably going to come up for us because we have people who still maintain licenses with not only the psychology board here, but psychology boards in other states. And if we keep the same thing that we have, that the patient has to maintain at least legal domicile in Louisiana, that's going to conflict with the SIPAC people. And I understand that legislation is going to be introduced in the next legislative session to bring Louisiana under SIPAC. So it's something that's going to come up down the road, and we'll just have to figure it out. But to me, they have to abide by the most restrictive rule, whatever it is, whether it's SIPAC or LSBME, if they're medical psychologists.
Well, the problem with the compacts have been that they are a bit of a pig in a poke. They give you one set of laws that you have to adopt, but then those laws say that notwithstanding anything in the state law, since it's the latest version of the state law in Louisiana, we can do anything and change the law and the rules for the pact, and you can't say anything about it. And we've tried to bring that point up over the years to the legislature, but apparently in this past session, without our input, the governor and his staff picked up on that and basically mixed a dietitian compact. And I think the leadership is beginning to recognize that they're ceding their authority to regulate to outside of the state. And I'm not sure what's going to happen with compacts in the future, but it would be helpful if you want me to look at if you get some SIPAC language, I'll give you some feedback that you probably ought to know about.
Yeah, I want to get they're bound to have a template that they recommend to states. I'm
Yeah,
not,
you can get it online.
you can, the template?
You can download it from online, yeah.
Okay.
And you need to understand all of these compacts and the explosion of them is being funded by the DOD and through one law firm, one organization in Kentucky. And that law firm and that organization do all of these compacts. And they all answer the same questions. Well, it's a state law and you have to follow it and we can change it. And I think, we try to make them all understand it's Louisiana. For example, criminal background checks. You have to have a criminal background check in Louisiana to practice. Well, what's going to happen is if you change the requirement for criminal background check, and this is what's going on in some of these compacts, we will give you the compact license and immediately open an investigation because you don't have a criminal background check and you got to get it done. And it's stupid, but that's the way the compacts want it. The other problem that we're seeing with the compacts is the issue of getting these things timely in a way that the data moves reasonably fast. With the oldest of the compacts is the IMLCC, and we move data from, for example, there's a request to the IMLCC for Dr. Collada to become a compact physician in Mississippi. The IMLCC sends a letter back to Louisiana saying you need to issue a letter of qualification on Dr. Collada, which contains 9 points, one of which is a current criminal background check. That then goes back to the compact, which sends that off to Mississippi. Mississippi, on the basis of that, grants the license. However, the OT compact, for example, and the speech therapy are combined in one organization, though they split up their work. They wanted us to send all of the data on all of the OTs to their database, and that violates 2 laws in Louisiana, one of which is you can't block transmit, and number 2, you have to transmit anything individually in a secure manner. And the solution to that is a system called application program interfaces, where the programs talk to each other and ask for and send data back and forth based upon predetermined requests. So again, a lot of this is evolving. And like I said, I'm happy to give you feedback, and if you send the pattern law, we can all talk about it and you can be prepared for it, and I'll talk to Bud about it as well.
Well, I think most of the people that are going to be interested in doing it are members of LPA who are licensed by LSBME, but we have people who are medical psychologists that have dual licensure, so it could affect us. So I'll see if I can get that template to you.
All right.
This may be a little bit, this may be a little off subject, but I've gotten stuff from LCMC about CMS changing the telehealth rules either on September 30th of this year or January 1st. Has anybody heard anything further about those telehealth rules?
No, it's still in development. I researched it. I research it about once a week to see if they've moved on it yet, and there's nothing yet.
Okay. Thank you very much.
Okay, and the next item on the agenda is just another question. Van, you said because of the number of people that were showing up in ERs around the states with adverse effects from the semaglutides, that the board might issue an advisory opinion. Is that still something that the board's considering doing?
Well, at the present time, the obesity rules are in process and they address this, okay?
Okay.
But the real issue is if you all want to prescribe it, okay, we may have to come back and revise these rules to address it specifically because technically it really is out of the scope of prescribing for a psychologist or a psychiatrist, actually. Psychiatrists can get away with it because they're MDs, but the problem is nobody in those two arenas are routinely treating diabetes or anything else, and they're not able to treat the complications. So what we really don't want to do is have people that get complications and don't have anybody to manage them.
Right. Okay. Yeah. Well, for us, there's no FDA indication for psychiatric disorder at this time anyway, so. Okay, and the next item is has to do with the categories of medications for the advanced practice application. And you recall in the law revision, we went from major psychotropics and major antidepressants to some different language that Carla worked up for us. And we discussed it a couple of meetings ago, and I think there were just a couple of things to tweak. And one of them was like adding antidepressants to anxiolytics. But I just wanted everybody to take one last look at this and see if anybody has any suggestions or revisions before we go forward with this.
Would O be considered appropriate for the dementia drugs?
Probably, yes.
Okay.
Yeah, because they don't fit in any of the other categories. Yeah.
Right.
So everybody okay with it? Can we have a motion to accept that language?
So moved.
Second.
Before you take the vote, there's no public comment.
Thank you. Is there a second?
I'll second.
Okay, all in favor?
Aye.
Okay. This is a question for Lauren.
I only
Patricia.
heard one voice. Did everybody else say aye as well? It does have to be a voice vote.
Aye.
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 Thank you. Thank you.
Okay.
I know you.
Can
This
we?
is keeping us honest, believe me, you wanted to do it.
Yes, definitely. Can we include this in the application now? It's in the law. Do we have to wait for the rule to be finalized before we can put it in the application?
You want this document on the screen to be part of the application.
Yes. I want it to replace the one that's in there now.
Lauren, how is the rule specifying the medications now? Is it in a manner prescribed by the board?
I
No.
don't know off the top of my head.
No,
It-
the rules say these exact words now in the revisions because we changed the wording in the law.
Okay, then what we would have to do is take this language and
Let's see.
incorporate it into the rules. And
But
then it would have
this
to go through the
language-
process.
This language is in the law that we just passed also.
This is
So-
a good time because I did have a few other things that when I was changing everything from physician to PCP that I wanted to bring up to y'all.
Yeah, so if you look, the law says these exact words now, and under 3911, she has listed it exactly the same way the law reads. A range of psychotropic medications, including but not limited to antipsychotic, antidepressants, blah, blah, blah. So that's exactly what our law says now too.
Only thing is there's no other category here.
Right.
So the question is, can we go ahead and include this in the application, or do we have to wait for the rule to be finalized?
I'll
And my-
defer to Patricia on that. I don't know.
Yeah, in my opinion, you don't have to wait for the rule. The rule implements the law, so the law controls.
Okay, that was my impression, but thank you. So is Matthew with us today?
Yes.
Matthew, can you and I get together and work on that one? Well, it's actually more than one sheet because it asks for I think 100 patients. So, but the initial page, just work on that and get that into the application. I'll be in touch with you.
Matthew, are you
Okay.
still there? Oh, he's muted. I don't know if you've stepped away.
Okay, I'll contact him on Monday.
All right, we'll talk to him.
While
Okay.
we have these up, before we move on, I did want to I was going through and changing all the physicians to PCP, and so there were a couple questions that I wanted to clarify with y'all while I had you. We don't
Sure.
need this definition of primary or attending physician anymore, right? Because that's not used in the law. I mean, used in these rules. We can keep it just cause, but we're not using that phrase, so I'm not sure that that phrase needs to be defined.
Well, there's a group of MPs who work in hospital settings, and so they primarily work with attending physicians, and they're very sensitive about having that in there because they're not working with the patient's primary care provider.
Gotcha.
They're working with a hospitalist or a specialist or something, and so they were very concerned that that not be dropped from the law.
Okay, perfect. Because in primary care provider, it does say the principal treating or attending physician, and
Good,
then
okay.
we'll just keep that defined there too. Alrighty, and then this part, this is for the advanced practice, and y'all require written recommendations of 2 collaborating physicians.
Right.
Do you want to keep it as just physicians, or did you want to open it to PCPs that are collaborating with it?
I think it has to be
MPs.
physicians.
Mhm.
Okay. I just wanted to make sure before changing all that.
Yeah, I think it has to be physicians.
And then the last thing I highlighted, where is it? Limitation of practice, a medical psychologist shall not employ a physician or enter into a relationship with a physician. Do you want to keep it limited as physician, or do you employ a primary care provider?
You know, I thought about that, Lauren. I don't know. To me, I don't know. There's a potential conflict there, I think. Um,
Which part of the law is that?
Is that part of 6113?
Yeah, 6113.
Okay.
And that's in the law.
yes, the part about physician is in the law.
So you shall not employ a physician or enter into any independent contractor or similar contractual or financial relationship with whom he or she consults or collaborates. Okay.
Well, I'm going to say this,
I-
if, based upon the way we look at the primary care provider, I think you should make it the same for that, because basically you all are going to be then assuming the responsibility for the management of those people. You'll have to have a supervising agreement, a collaborative practice agreement. And I don't think APRNs are going to be allowed to collaborate with medical prescribing psychologists.
The way I'm reading it, I don't think we need to change it because I think the intent was to say you can't hire your own doctor to be your collaborator in your office. You have to collaborate with someone who has a relationship as an attending or primary care. And you can't, the rule and the law already says you can't do, a nurse practitioner or PA can't do that anyway. They can't be the ultimate person who collaborates with you. Am I reading that correctly?
Well, I mean, even though a nurse practitioner might have a physician collaborator, to me, it's a conflict if you're employing that person. There's always, to me, a potential conflict. I like it the way it is. I like it the way it is, but I'm happy to, I mean, maybe we need to add the other two.
So if you leave it like this, then I can hire a nurse practitioner under my umbrella, and then they would be able to collaborate?
Well, here's the thing. At the present time, nurse practitioners can only collaborate with physicians. So with all due respect, you all
Yeah.
are not physicians.
What the law, I think, allows is nurse practitioners can refer to us and we
Mhm.
can take those referrals. But ultimately the physician is still the person you have to have final collaboration with it for things. The nurse practitioner is not, and neither is the PA. So if you wanted to hire a nurse practitioner under your company umbrella, that nurse practitioner still has to have a collaborating physician who would be the person that you would ultimately have to collaborate with for things that require that.
So let's run with that. So let's say that is in place. Nurse practitioners under my umbrella refers Joe Blow to me, and then in order to satisfy the law, then I have to turn around and make sure I at least send a note to that nurse practitioner's over.
Technically, Chris, you cannot collaborate with an APRN. The law is clear. Collaborative practice with APRNs are by physicians. Now, if y'all want to change that in the law, it's something you're going to have to go up and deal with in the legislature.
I think
Okay,
you
well
were,
then
Chris.
this
let me see-
says when a medical psychologist consults and collaborates with a primary care physician other than, I mean, a primary care provider other than a physician.
Mhm.
So
I think they're
collaborate
using
should
the
be
word
taken-
collaborate in a generic way and not collaborate in the official way of being the collaborating
Correct.
provider.
Right. I think the semantics are getting confusing.
Could use the word consultation, yeah.
Yeah.
Problem is that collaboration is now pretty much a term of art, wouldn't you say, Patricia?
Yes, yes, that's what I was trying to say, not as elegantly as you did. We should, when we're talking about these kinds of relationships or contexts, we need to not use collaborate unless we mean someone who has a collaborative agreement with another person, a
Mhm.
physician.
Okay, so I'll take the collaborate out and it'll just be when a medical psychologist consults with a primary care provider
That would make the
other
most
than a
sense.
physician.
Yeah,
Mhm.
because you're right. Collaboration is it's a signed contract between the APRN and the collaborative physician.
What does what the language in the law say? Because we just redid the law. I think it still has collaborate in the law.
We don't have a problem with that because it still says
Primary
you.
care physician, right?
To me, the collaboration is ultimately always with the physician because they're the person managing all of this.
So the example that I have, so I have a psychiatric nurse practitioner that works with me in my practice as a contract employee. He doesn't refer to me. We don't do any cross referrals, but let's use that as an example. He has a signed collaborative agreement with a psychiatrist, Dr. Simone. So Ryan is the nurse practitioner, Dr. Simone is his collaborating physician. So if he were to refer a patient to me, then I would just have to make sure as a medical psychologist that I send the note to keep Dr. Simone informed. Would that be correct?
I think so, yes.
That's how I
Yes,
would interpret it too.
yes.
So then the question is the use of the word collaborate, because technically his collaborating physician is Dr. Simone.
Correct.
That's correct. You cannot be the collaborating person.
Right. So it's that use of the term collaborate that gets a little squirrely for us. Because it means two different things. It depends on how you interpret it, I guess.
Yeah, if you're using it in the generic sense versus using it in the legal official sense
Mhm.
used throughout the Medical Practice Acts.
And is that NP anybody's primary care provider?
In this example that I gave you, it wouldn't be. He's a psychiatric nurse practitioner. But it could easily stand that, I could hire a nurse practitioner that is a family practice kind of nurse practitioner, and I could try to set up some kind of a internal referral process as long as then I send a note to that legal collaborative physician for that family
But is
psychiatrist.
that family nurse practitioner going to be doing family medicine as well?
So again, I don't have that set up, but I could see that
I-
that could.
Where
I
you,
could-
that you would be way out over your skis because you are the employer and you are ultimately responsible for that APRN.
Glad I'm not doing it.
But it also has enter into an independent contractor or similar contractual relationship, financial relationship with.
Because if that person is doing, let's say, treating diabetes and giving GLP-1s, you're responsible for them because they're
Yeah.
under your scope and employment.
But I could see how that could, I could see how that might happen. Now, when we
Well,
open up
again,
this nurse practitioner stuff.
Well, again, I think the key is keep it clean. You all need to not be hiring these people.
Mhm, exactly.
Y'all need
I
to be
agree with
working
that
with.
completely.
This is never designed for y'all to hire. This was designed for you all to be consulting with and consulting for.
This is just something that I just don't know. But like, what if the only access, like the only touch point to the medical system is that MP? Like they could just become their primary care physician, right? Like if they don't have a family practice doctor.
They're not a
I don't
primary
think that
care
would-
physician.
That wouldn't meet the definition of primary care in these rules.
Okay.
So I do think that, the conversation we're having here about getting over your skis and everything, I think
Yeah.
that language prevents that.
We hope it does.
Yeah,
Yeah,
good.
so it sounds like it's good the way it is.
Okay. Perfect. I just wanted to chit chat about that before we completed this.
Okay, good. Let me just ask you about the language in this medication thing. And as Darla said, this is really straight from the law. But it says treating a minimum of 100 patients, documenting a range of psychotropic medications, including, but not limited to. So does that mean that all of those should be included?
That is where rules elaborate and clarify the law. And if you take the exact language of the law, then that's what the rules are going to say. We have the right to clarify, but not expand or I should say not restrict beyond. Isn't that correct, Ms. Patricia?
When I read including, that says to me you have to include all of those. And that's not going to happen necessarily in a child clinic. You might not be prescribing antipsychotics, particularly if you're dealing with young children.
Yeah, so the
Or an adult
rules,
practice where you might not want to use stimulants.
Yeah, exactly. So does including imply that all of those have to be included?
Well, the other question then is if you say, well, you don't have to use every single one, then you're going to have to say, well, how many do I have to use?
Yeah, it's vague because uh, we're basically asking for a range of medications rather than all I do is prescribe stimulants because I only see children. So I don't do anything but stimulants.
Yeah,
Ju-
I mean, what that is, what the expansive view of that is to say these are permissible, and then the rules can implement that in a way that makes sense and protects the public, et cetera, et cetera. You can't take away somebody's authority by rule if it's granted by law, but you can clarify and segregate and apply the right circumstances to the right context within the course of the rules.
Can I say something about this? So that last sentence that says documentation of clinical experience must address, we added that last sentence at the last meeting where we discussed this to address just the issue just brought up of they only prescribe ADD meds or they only prescribe antidepressants. We decided to add this sentence to indicate that we expect them to have a broad range of diagnosis and treatment. Now, we
Well-
did not discuss at the last meeting whether including you had to include every one of those. I think that's more of a legal question than a semantic question, probably, I guess. But if we feel like it does, we could just change it to something that's more inclusive, which may include but is not limited to.
Wait a minute, I'm a little bit confused. I thought you said all of this is exactly from the law, and now you're telling me that the last sentence is not in the law. Is that correct?
The last sentence was not in the law. It's something we decided to add at the last meeting where we talked about these.
To
And I
clarify.
actually think it was you, Dr. Van, that was like, maybe this would be a good way to say that, because we got into
Yes.
this whole discussion about if you only treat ADD, do you really meet criteria for clinical experience? So that's why, so that one sentence we did add, but everything else is pretty much written as it is in the law.
Well, again, are there any other sentences in this, in what's on the screen that are not in the law other than other and that one?
Well, the information below the classification of the medications was what Darla put together. That's
Okay.
not specifically in the law.
Okay, so then these are rules and they are designed to do just what you're doing. So again, the only thing that I'm understanding is in the law is this. Is that correct?
Right, but you have to keep in mind too, the principle of statutory construction that says the law can't lead to absurd results.
Right.
So it would be based on how life really works in your field. It would be I'm taking it that there would be categories of practitioners who, by nature and virtue of their practice, do not use each and every one of these drugs, modalities, whatever. And so it would be unusual or leading to potentially an absurd result if you said everybody has to have used every one of these. That's not the context or the implication of the way this law is written. This law says you have to document a range that includes but isn't limited to X. So you have to include some of these, and you can have others because it's not limited to these, but you don't necessarily have to have used every single one of these to have the required experience.
So,
And-
Patricia,
Howard-
if we said may include,
Right.
but not limited to, because I'm concerned somebody's reading this, it says including, and they say, oh my God, I gotta use all of these. I better
Yes.
find a kid
Why
I
don't you
can
say-
give an antipsychotic.
Well,
to.
based on our reasonable interpretation of the law, and so as not to make it lead to absurd results, the rules could use the language may include but not limited to, if that assists the practitioner in meeting these requirements.
Alternatively, you might want to say documentation of clinical experience must address a broad range of diagnosis and medication uses and is reflective of the applicant's clinical practice. And that way I think you get what you want, so that if they're only doing kids, they have a different one than somebody who's doing elderly.
Well, I like the idea too of in that highlighted section right now where it says may include in other words, change including but not limited. Take that out and put documenting a range of psychotropic medications, which may include antipsychotics, blah, blah, blah.
Yeah, I like that. And I like what Van said too. I think if we do both of those things, it's not going to confuse anybody. It's going to
Mhm.
help clarify for them that they're not required to use all of those.
Yeah, that would be the intent. I mean, because when the committee looks at these applications and somebody shows that, you know, you've been seeing that 70% of their medications are stimulants, you know they've been in somebody's pediatric practice or a child psychiatry practice or preceptoring or something like that.
Mhm.
Well,
Yeah.
I think you have to cover it with range then too, because you don't have a chance to go back and fix it down the road if they suddenly expand their practice and they have not demonstrated any experience with a bunch of these. They've only used one or two because of the nature of their current practice. But yeah, I mean that's covered by the request that or the requirement that they document a range.
Okay. So can we say may include antipsychotics, da, 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 da?
Well, then that still doesn't, I think the but not limited to, as we got back to a while ago, includes that other category.
Yeah, if you say may include, I mean this is just a term of art in legalese and the way things have always been drafted. I don't know if we put it through Microsoft Word editor if it wouldn't tell us that that's not necessary, that may include by its very nature means it's not limited to.
Okay,
But
as long as that's what we're intending, that's good.
yeah, yeah. But you know, but since it's in the law, if if you want to say may include but is not limited to, I mean, it's sort of up to you. The
Well,
problem with that is when you get to the rules or your policies for evaluating these things, what else is there that you would consider appropriate things to have used that demonstrates the range of psychotropic medications? I mean, what else is there?
I don't know if I understand your question.
So we say treatment, or the law says treatment of a minimum of 100 patients documenting a range of psychotropic medications, including but not limited to, and then we list these.
Mhm.
That implies that there are those that are not on the list that you could still use and still demonstrate the range. And my question to you, because I don't know, is what other things could they possibly use that you would consider documentation of appropriate experience?
As Dr. Dons just said a while ago, medications that could treat dementia or memory loss. And then
Mhm.
we had a couple of applicants recently who used other medications that were not FDA approved, but they had done they had research showing the clinical trials or data that this might be appropriate. So any of those type of things could be included in that other category. I don't remember what the medicine was, but I do remember we had that with one of our
Okay,
applicants.
good enough. I wasn't sure.
And some things are going to come along. You know, psychedelics are getting a push. So the other kind of opens it for any new types of medications that might come along, medical marijuana,
We'll have to
whatever.
have another meeting if that happens.
Hmm.
Okay, any more on that then? Are we kind of,
Just to make sure that under psychiatric diagnosis, the use code below, that should
That
be
the use
That-
code below should be under type of
type of
medication.
med-
That's just a formatting thing.
yeah, it'll show up on the form.
Mhm.
And you're gonna go over that form with Matthew, correct?
Yes.
Okay.
All right, we're ready to move on from that. Okay, we need to go into executive session. We have one application to review.
Jacinta and Melissa, can you all move us into executive session, please?
Somebody, just for
Yeah.
formality's sake, somebody want to make a motion, take
Oh,
a
yeah,
vote?
motion, please.
So moved.
And you have no
Second.
public comment at this time.
Is there a second?
Second.
All in favor?
Aye.
Aye.
Think you got everybody in the meeting?
Looks like everybody's back.
Warren, you're muted, so we can't hear you.
Still muted.
Hit it again, Warren. There you go.
Nope.
Warren,
It keeps going in and out.
yeah, I'm sorry, Warren, we don't know anything you're saying.
That's
I'm
good.
sorry.
I hear you now.
Can you hear us? Yeah, but we can't hear you.
Say something. Your mic is like no volume.
It was working so well for most of the meeting.
Nothing like IT. Anybody read lips?
I mean, can one of us do the rest of it and he can just vote by raising his hand?
Supposed to be a voice vote. Technically, under the law, we're supposed to suspend the rest of the meeting until we can fix it. So, Warren, can you do me a favor? At the bottom left hand of the black window for this meeting, you see your little microphone, and to the right of it, an up arrow. Click on that up arrow, and you'll see something that says audio settings. Click on the audio settings, and then you'll see something that says microphone. Do you see that? In the settings, you'll see audio on the left. It starts with general, video, and then audio. Make sure you highlight audio, and then on the right side, you'll see below it speaker and then microphone. You see microphone? Don't know where, if you don't nod your head, I don't know if you see it or not. If you see microphone,
Yep.
okay, good.
Sees it.
And down below it, you're going to see input volume. Can you raise that input volume? Okay. And let's see if it works. Okay, and that doesn't work. Under microphone, you're going to say a window that says microphone array, microphone Logitech, system as says microphone Logitech. You see the little right arrow, click on that right arrow, and you may have a number of choices. We need to pick the right one.
All right, I'm trying a
There you
different.
go.
Hey!
Hey, you're back. Yay.
Hey.
Hey!
right,
Bravo! Bravissimo!
The meeting
Van-
can proceed.
Van, that needs to go into telehealth rules.
Van, I just want you to know I could have gotten that on my own, but it would have taken me about 6 years.
Well, I'm glad I could be of help.
Yep, we better hurry up.
All right. We're back in regular session. Do we have a motion on the application for advanced practice?
I
So
do.
moved.
I motion that application 291714 be approved for advanced practice.
Second.
All in favor?
Aye.
Aye.
All right. Van, do we have any public comments?
Nope. Double check 1 second and make sure, double sure. No public comments at this time, sir.
Okay. Motion to adjourn?
So moved.
Second.
Thank you all for all you do. We enjoyed the conversation. It was very stimulating today. Have a great day.
I appreciate all the work that you did. We had a very productive meeting today. Thank you.
Thanks,
Thanks.
everybody.
All right.
Have a good
Bye.
weekend.
Good night, everybody. Have a great weekend.
Bye.
Thanks.